everybody. Good morning, good morning, good morning. Some shout outs here. Corey H., Molly Swift, Dorothy Shadwell, Patty Ward, Marie Burks, Steffi, History Underfoot, Yum Diddly. Hello, hello, everybody. Pamela, hello, good morning. Elizabeth, Veronica, good morning. Lori, good morning, everybody. Good evening from Sweden. Wow. Canada says good evening. There's Rosie. Hello, Rosie. Carrie. Debbie Johnson. Hello, Jessica. Hello. And thank you for being here. Thank you. I appreciate that. Tanya, Sammy, hello, and good morning, good afternoon, good evening, depending on where you are. Carrie MC, it's a beautiful day in Nebraska. It is cold, raining, and yucky here. I wish I was in Nebraska right now. Good morning, everybody. Good morning, Nana. Nana, good morning. So what we have now, you guys, I've had to kind of backdoor to get a lot of this information. Good morning, Mountain School Girl. My sister will be in here momentarily. Warm in New York City today. Wow. I wish it was, excuse me. I wish it was warm here today. We've been having a lot of rain, and it's, I'm kind of just counting my blessings because I'm in Canada, and Northern Ontario, more farther north than what I am, and Manitoba, Saskatchewan, and Alberta got anywhere, depending on what province, got up to 100 centimeters of snow. So that's about 4 feet, 4.5 feet, for those of you who are not using metric. So yeah, it's crazy. So I'm just grateful that we didn't get that. Good morning, Real Angel. Kate Does Crime. Hello. Yeah, blizzard. It was bad. So I haven't had a chance to go and check that all out yet. I have family that lives out west, so yeah, it was supposed to be nasty, really bad. I guess people can't get out of their houses, and it's been really bad over there. I had an incident yesterday, you guys, so I'm going to briefly go through these documents. I had an eye injury yesterday, and I had to go in and have them scrape out whatever it was that happened there. My doctor said just put drops in it. And I don't know if it's when I tried to scratch my eye or what I did, but I did something to my eye yesterday. So it's been giving me really bad headaches and whatnot. And he just said to continue to put the eye drops. So yeah, it's my luck. It's just my luck, you guys. So my eye is not very good this morning. It's sore. It's not as bad as it was last night, but it is sore. So to get these documents, you guys, and like I've been saying, I don't know what is going on in the Barry Morphew thing, but they are not putting the documents into the court filings for some reason. So I really had to search. Thank you, you guys. Thank you. Thank you, Shelley. I really had to search to get these documents. I don't know why they're not putting them into the record, because there is a lift on that now that they are supposed to put these into the record. The only one that I could see was the one I showed you guys the other day. Let me just see if I can pull that one up. Oh, God, where did it go? Hang on a sec, you guys. I got it here somewhere. Ugh, I'm just not organized at all. And I apologize. Please forgive me. Okay, here it is here. Let me share my screen with you guys. Okay, so this is the one that, sorry, you guys, it is now in the record, but I had to go to Scribe and get this. This is the one that I went through with you guys the other day, the response to the prosecution's motion to reconsider and defense motion to dismiss case. This is the one I went through with you guys the other day. Now, we never got to see what the prosecution was saying. And lo and behold, Lindsay is back in the picture. So this is the one, if you haven't seen that video, go a couple days ago, I went over and covered all this video. Okay. Now, what I did get was, do I still have it here now? No. What I did get is, see how I had to download each page. So what we will be doing is briefly going over this, okay? But before we do that, I want to show you something else. Hang on a second. Where is it? Oh, God. Willow, get your crap together here. Okay, so what I'm going to do is I'm going to read this. This is some information that I got from one of the news channels. So it's briefly going to tell you guys the gist of what's going on. Then we'll go over the actual paperwork. Like I said, I just got this paperwork, and some of it as late as just an hour ago. I was having a really hard time trying to get copies of what the prosecution had filed. Why they are not putting it into the record where we can see it, I don't know. But it seems to me like they are trying to keep stuff from us for some reason. Oh, thank you, Maui Swift, for your super sticker. I appreciate that. So as I am reading through this, you guys, I have my YouTube studio open. That's how I just seen Maui Swift's. And what it does is it flashes up on my screen when somebody has placed a super sticker or a super chat. So if there is something in here that you want me to stop, you have a question on something, excuse me, I see these flash up. I don't see your normal chat. But when I have my YouTube studio open, they flash up on an independent screen that I have there. So it stands out. So I see that something's flashed on my other screen. That's something I've learned recently that I can do because I've been missing super stickers and super chats when I'm reading documents like this because I can't see chat. My chat is not there. So I did figure out how to do that. Like you guys know, I am not good with technology. So if you do have a question that you want me to stop and answer for you, if you want to throw up a super chat, super sticker, go ahead. It's not necessary, but if you do want me to see it and want me to answer it, that's the best way to do it. So this is just going to give a synopsis of what has gone on. I do know that the prosecution has filed more documents, and I am still trying to find them. Like I said, they're not putting them into the record for some reason. So let's go through this. I'm going to read it the best I can with one eye here. And then we'll go over the documents so you guys can see them. I'm not going to read everything in the documents because there's a lot of pages there, but I will go over the main parts of it and scroll through it slowly. So when you guys do want to go and watch the replay, if you want to read it word for word, you can. Like I said, these aren't on the court site yet. Excuse me. So it's not like I can just take my time with them. So, okay, so let's go over the basics. And thank you again, Maui Swift, for your super sticker. I appreciate it very much. Shows your appreciation. Okay, so this is from one of the news outlets. I'm going to read it. It says that the documents obtained from the Fremont County clerk. So they actually had to go in and get their documents, okay? You couldn't find them online. Through a records request revealed the prosecution team in the Barry Morphew case has asked the judge to reinstate key expert witnesses in the case, saying these experts and their testimony are critical to the people's case. The prosecution's motion for consideration of the court's March 10th, 2022 order to strike various prosecution experts due to their pattern of violations of court orders and Rule 16 is included in the documents. Okay, so Fremont County Judge Ramsey Lama on Friday declined to dismiss the case against Barry Morphew. So this came out on April 11th, so a few days ago. So they're talking about the last hearing that they had, okay, where I did read you that order. Now, the prosecution has filed more documents. There is another court date coming up on the 19th, okay? Yeah, I realize that, Rosie. This is just stuff that I've gotten written down. I'm going to show you the documents as soon as I'm done reading through this. And then I will show you guys the documents. Hang on a sec. I can share. Okay, hang on a second. Yeah, you're going to have, I've got this up on my other screen, so I can't. I will show you guys the documents. Right now, I'm just reading through a synopsis of the overview. Thank you, Elizabeth Gregory. I see finally prosecution is responding. A little snarky too, which finally, by the way, did they wait till now? Yeah. Okay, so they're saying here that that on the Friday, so that would have been the 8th of April, Judge Ramsey Lama declined to dismiss the case against Morphew, who is charged with first-degree murder in connection with the May 2020 disappearance and presumed death of his wife, Suzanne. However, Lama issued sanctions against the prosecution by excluding 12 of their 14 endorsed expert witnesses, stating in the order that it was significant but warranted sanction given the record of compliance with the court. Now, I said it when we were going through that order that Judge Ramsey gave. I said that is extreme because you're basically throwing their case out the window. You're excluding 12 out of 14 of their expert witnesses. Okay? So the court indicated a continuing pattern by the prosecution to fail to comply with obligations under Rule 16, which in their obligation to turn over discovery ahead of trial. The judge wrote, their actions amount to negligent and arguably reckless disregard of the rule and subsequent orders. Yes, I'm trying, yes. So the prosecution had said their case will be very much damaged at trial. It will be substantially impaired if they are not able to call these witnesses. But remember, that was the judge's order. They had violated discovery rules, and as a consequence, they would be barred from calling these witnesses. Now, yes, take 1 or 2 of them away, but to take 12 out of 14, that's their whole case, right? Morphew's defense team accused the prosecution team of committing discovery violations, stating that the people failed to comply with the case management order. The defense attorneys argued that the prosecution didn't turn over all expert-related materials in the case. Lama ordered that the experts, Megan Duguay, Ken Hicks, Kevin Hoyland, Andrew McDermott, James Stevens, and Officer Derek Graham, Johnny Grusing, Ken Harris, Andy Rorick, and Alex Walker. Now, there's 1, 2, 3, 4, 5 people in law enforcement that have been excluded, not be allowed to testify at the trial in their capacity as experts. If the ruling to exclude the witnesses stands, it's not the same thing as a dismissal, but it certainly cripples the prosecution's case substantially, to such an extent that they are now obviously panicking about their chance at trial. Okay? And yes, this all falls on the prosecution. The prosecution's motions say the exclusion of these witnesses damaged their case in a profound way. It continues by excluding the most damaging impeachment information against the defendant: the cell phone data, the truck telematics, GPS, and CDR locations. So the court has imposed sanctions tantamount to a dismissal. So you might as well just dismiss the case, because you're dismissing all the witnesses that can prove their evidence, right? So, and that's like the defendant suffering a complete windfall. It's relatively rare for a judge to exclude witnesses, Robinson said. I think it really speaks to the judge's perception of the seriousness of the misconduct of the prosecution. Now, the future of the trial to start on April 28th is in question, considering prosecutors have told the judge that their case is greatly hindered without the testimony of the expert witnesses. No, I didn't mean DA Stanley. Let's just be clear with that. It's the prosecution on, thank you, Elizabeth, again for that. It's not just DA Stanley. It's the prosecution on a whole. It's every piece of the prosecution, from those who are supposed to copy and send off information right down to the prosecutors. It is everybody in that prosecutor's office that had a job to do on this case, whether it was putting together all the disclosure and getting it sent over to the defense, people who were supposed to go through all the information regarding telephone calls, text messages, meetings that law enforcement and prosecution had. It's everybody in that prosecution office, not just Linda Stanley. Okay. Okay, so where am I here? So now the future of the trial to start on April 28th is in question, considering the prosecutors have told the judge their case is greatly hindered without the testimony of these expert witnesses. So what we should be looking for right now, they've gone, the judge has already made decisions on a lot of the defense's filing 17, 17A, 17B, 17C, 17D motions, but there's still motions that are there that the defense has now filed. He hasn't ruled on the D67 motions yet. So I do believe that that may be happening on the 19th. I do believe if there is something, again, more serious that's going to be brought up on the 19th, I'm afraid that the judge is going to dismiss the case. Now, what the prosecution has to do is they have to nip this in the bud real quick, or they have to apply to the Supreme Court to have this court heard by the Supreme Court. Now, for them, in order for them to do that, what they got to do is they got to send all their information that they have for their case to the Supreme Court and hope to God that the Supreme Court decides to take the case. If that's the case, then they would have more court appearances to see what information is going to be allowed in, etc., or have the Supreme Court make some kind of ruling on this as to the witnesses, because basically, without the judge saying he's dismissing the case, he's excluded 12 of the 14 witnesses that without them, they don't have a case. So right now the prosecution can dismiss this without prejudice and retry it on a lesser charge at a later date, or they can apply to the Supreme Court. That's how I know it works here in Canada. I don't know if that's how it works in the US. Like I said, I just got a lot of this information last night, so I haven't really had a time to go through the rules and that in the US, and a lot of it I don't have access to from Canada. So right now, the only option I see for them is if they want to go forward with this and keep the trial date as quickly as possible, because they don't want to put themselves either in a position of failing to provide a speedy trial for Barry Morphew, which he has not waived his rights to. And he will not waive his rights to a speedy trial. So do they take a chance and go to the Supreme Court, hope the Supreme Court goes forward with this for them? Or do they dismiss it and refile without prejudice and refile with a lesser charge, like second-degree murder or something? It has to be something that's changed. They have to receive other evidence, and stuff like that. So they're in a predicament right now, you guys. Okay, so once a jury is seated, okay, and the jury selection is going to be starting on April 28th. Okay. Hi, Leland. Oh, your treatment is more important. So thank you for being here, Leland. So once the jury is seated, the double jeopardy rule goes into effect, which means once that jury is seated, he cannot be tried again. Okay? So that means that if the trial moves forward and Morphew's acquitted, he wouldn't be able to be charged and tried again for the same crime. The charges would be dropped. If the charges are dropped before the jury is seated, prosecutors could bring new charges if evidence is found. Okay? So they have a big decision to make. Do they take a chance and give this to the Supreme Court and say, look it, we feel that the judge has been overzealous in discluding all of our witnesses, basically. Sorry, you guys, I do mute myself when I have to cough. Do they give this to the Supreme Court and hope and pray that the Supreme Court accepts it and tries this case? Because if they refuse to, then it's back at Judge Lama. And if he is found not guilty, if he's acquitted, he wouldn't be able to be, and the jury seated, then he wouldn't be able to be charged and tried again for the same crime. If the charges are dropped before the jury is seated, the prosecutors could bring new charges if new evidence is found, which means her remains or other evidence that points to him. Okay, so since the jury hasn't been selected yet, which happens on, let me just see here, the 28th, the double jeopardy would not bar a future trial if the case were refiled. There would have to be substantial new evidence to support a refiling of this case if it's dismissed sometime in the future. It is. It's a huge mess. So the prosecution on Monday, which would have been the 11th, filed a motion asking the judge to reconsider his order in regards to expert Duge, Hicks, Hoyland, and Stevens. The motion reads that these experts and their testimony are critical to the people's case. In the motion, the prosecutors say their case relies heavily on evidence of Morphew's motive to harm his wife, the opportunity he alone had as the last person to see Suzanne alive. That's when he showed up at home and she's suntanning out back. And the inconsistencies in the statements to law enforcement and the ultimate cover-up he perpetrated the day after and the following months. So the prosecution cites in the motion the importance of the expert testimony on data downloaded from the suspect's truck that disputes the defendant's initial alibi that he went to bed early on the night before Suzanne was reported missing. The motion also states that there's also information downloaded from several phones, included in the case, but specifically the data that was extracted from the defendant's phone that shows data was deleted in bulk before the phone was seized. So just before, like, he knew that the police were going to be seizing his phone, his laptop, his computer, whatever, any electronic devices. He knew that. So in bulk, he deleted a lot of stuff from his phone, which were like included, I think it's like 300 and some odd texts and 25 calls and 58 saved locations. Okay. And the cell phone data tracking information used from Suzanne's phone and information extracted from the defendant's truck, the Bobcat, and phone helped the prosecution determine a timeline of the events between the day before she actually went missing and May 10th. Okay, so that's like, I believe she went missing on the 9th. So experts from the prosecution list also includes testimony on the data from the defendant's F-350 truck, other data from physical items, and information obtained by the search warrants. Okay, so, and it's just gone crazy, you guys. Because then the defense team filed a response to the prosecution's motions, asking the judge to deny the motions. I did go over that with you guys. That was the only one that I was able to get. I did go over that with you, so I'm not going to go over it again. You'll have to go back and watch the other video on that, where we go over the defense's response to the prosecution's motions. Now, we were never able to see the prosecution's motions. They're still not available on the site, but I've got my hands on them, and I'm going to show you after I give you a brief overhaul of what's happened to date. So the defense team had responded that the facts in the case are insufficient to reach a murder conviction, and the stricken experts do nothing more than bolster uncorroborated theories and hunches that the prosecution would like the jury to adopt, and what would be like a wrongful conviction. That's what they're saying. And they're also, we know they made a comment a few days ago saying that this isn't even, this is just a missing person trial. This is a missing person. No, he's been charged with first-degree murder. This is a murder trial. It's not a missing person's case. The defense team says that 6 weeks after the prosecution's alleged deadline to provide expert disclosures to the defense, and 3 weeks after the court struck these witnesses, the prosecution now wants to provide information to the court with new information and reports that it claims are critical to prove its theory of murder. The defense counsel also says the district attorney's office is experienced in numerous high-profile, high-stakes cases, and to think that this prosecution team cannot comply with court orders and behaves in this way is just negligent, ludicrous, and is certainly willful. So they're going to be trying to say again, we know that there's more that has come out now regarding this dog handler. So that's what I believe they're bringing the new motion. The prosecution's bringing the new motion on, is that they want at least these people. I don't know what's going to happen, you guys. The 19th is, if they wait till the 19th for these motions to try and get some of these experts back, they're cutting it awful close to be able to apply for the Supreme Court. So the defense actually cited factual errors, dishonesty, prejudice, misstatements, ethic violations, and outrageous governmental misconduct, violations of court orders. And in its reply, the team asked the judge to deny the motions to reconsider, and once again is going to be asking the judge to dismiss the case. In a reply to the defense's motion, the prosecution said they disclosed all necessary materials associated with the witnesses. They again asked the court to reconsider expert Duge, Hicks, Holland, and Stevens. So on the D17 motions, which are the defense's motions, which we've already heard about, that the judge didn't order the order that we just read the other day. Okay, that was on the D17 motions. There's still D67 motions that the judge has not ruled on yet. And those are the ones that I'm worried about. If he rules on that, like, look, here we go again. You guys didn't turn this over, blah, 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 blah. He may dismiss the case. And it says here on the Colorado court Twitter, says People versus Morphew, the order regarding the D17 motions, which are the defense 17 motions, and we know there was 17A, B, C, D, E, F, whatever. The court concludes additional sanctions are not appropriate at this time. However, this order will serve as the baseline for future orders related to discovery violations. The case is going to be set for trial for April 28th. Now, apparently there's more that is coming. And those are the defense's 67 motions. The numbers that I'm telling you are the amount of the number of the motion. So we're at 67, A, B, and C. So these are defense number 67, A, B, and C motions. So 67 motions they filed. It's like crazy, 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 crazy. So yeah, they've taken away 12 of the 14 expert witnesses. There's also other charges that he is still facing, which is possession of a dangerous weapon and attempt to influence a public servant, as well as a totally separate one regarding the voter fraud. AK is taking a break right now. That's all I'm going to say about it. When it comes to AK, that's not my information to put out. But right now he is taking a break. So that's where we stand right now. There is another court date on the 19th. So do you guys want me to show you the information that the prosecution filed? And what I can do is I can go through these pages because it does give a little bit more information as to what the prosecution may still use. Is there enough in there that they still have? I don't know. But I can go through it. I'm not going to be able to read through all this, you guys, because of my eye. But I will go through it slowly. So if you guys do want to go to the replay and read through this, you're more than welcome. There is going to be a few things that I'm going to maybe comment on here that I think are... Okay, I'm seeing yes. Okay. And these are the ones that aren't filed. It's very hard to find these documents. I don't know why, but... Okay, so again, I cannot see the chat now, you guys. So if you guys do want me to stop at something, throw up a super chat or something so it flashes on my other screen and I know to stop. Now we have to go through these individually. So that's what we're going to do. Okay, so this was filed, and like I said, by Linda Stanley. Okay, and it was filed on April 1st. These are the ones that we could not see. They are still not in the public access forum on the court's website. These are still not there yet. Why? I don't know. Okay. So this is the people's motion to partially reconsider the March 10th, 2022 order striking expert witnesses. Sarah, let's not attack. I'm going to remove that. Please, let's just let people, as long as it's done respectfully. I don't care if there's berries.
This might answer your question.
Oh
According to the U.S. Census Bureau, the world population today is approximately 7.89.
I don't know why Alexa decided she needed to put her input in there. I don't care. I don't care if there's even Barry supporters in here, as long as they get their point across respectfully. And I'm not going to say that St. Elmo's Fire is wrong there, because Eden is a bear. She is evil. No problem. I just don't want anybody feeling like they can't put a question in without somebody, other people in chat, Sarah, and there's nothing against you personally, hon. It's just other ones. I get that. I get that, Sarah. But I don't want anybody to take it like that either. So that's why I removed it. So it's a safe place for everybody. Like I said, even if there's people in here that are pro-Barry, as long as they put their points across respectfully, they're allowed their opinions too. Or stuff like that. Like it could be taken a different way by others, Sarah. That's the only reason I removed it. Yeah, Eaton is evil. She is going to go for the juggler on anybody that gets on that stand. So I do kind of agree with that. So hello. Okay, so I just happened to see that as I was trying to get this up. So like I said, if there's questions or anywhere you want me to stop, I've got the other screen up now, where it will flash if you put up a super sticker. Okay, so the people's motion to partially reconsider. So we remember on the March 10th order, the judge striked 12 of the 14 witnesses. Okay. So in multiple filings and through oral argument at various hearings, counsel for Barry Morphew has accused the people of committing discovery violations, stating that the people failed to comply with the case management order, in this case extended by the court for expert witnesses, and that the people failed to timely furnish almost all materials related to several experts in the case. Based on the assertions of defense counsel on March 10th, the court ordered that several of the people's endorsed expert witnesses and will not be allowed to testify as experts at the defendant's upcoming trial. The order named Megan Dude, Ken Hicks. Okay, there's all the names here. I've already gone through that. However, following the court's order, the people reviewed the discovery disclosed in the case to date and determined that the people disclosed all necessary materials associated with Megan Dude well before the deadline imposed by the CMO in this case and the court's extended deadline. As of February 28, 2022, and with the exception of their curriculum CV discovery on March 1st, 2022, a day after the court's deadline, all other materials associated with Ken Hicks, Kevin Hoyland, James Stevens, as detailed below, were also discovered to the defendant well ahead of the deadline. So do you remember me telling you guys that the prosecution said, look, we gave it to you. And then the defense came back and said, oh, well, you sent it with 4,000 other pages of discovery. How were we supposed to find it? You buried it. Well, that's not the prosecution's problem. You asked for all this information. If it was 4,000 pages, it's 4,000 pages. Here you go. It's not up to the prosecution to point out the page that each of the information is on. Okay? They got the information. It's in there, point blank. Okay? Okay, where was I here? Well ahead. These experts and their testimony are critical to the people's case. So this is what they are fighting for now. And this may come up again at this. If they wait and they go again on the 19th, which I don't think they should wait. If they have a chance at all at getting this stuff in, it's going to the Supreme Court. So with that being said, they have a choice to make. Either they hand this to the Supreme Court and say, look it, we need these. Please look at our information. The trial judge made an error with excluding these witnesses. We need these witnesses. So they have a choice to make. While most materials associated with the above named law enforcement experts were also timely discovered, the people are not requesting any relief in regard to the court's order as it pertains to these witnesses or Mr. McDermott, who has yet to complete an expert report in this case. As the people have complied with or substantially complied with the expert discovery, deadlines for Ms. Duge, Mr. Hicks, Mr. Hoyland, Mr. Stevens, and the defendant is not prejudiced by the people's single-day delay in providing CVs for Mr. Hicks, Hoyland, Stevens. The people request that the court partially reconsider the order and allow expert testimony from Megan Dude, Ken Hicks, Kevin Hoyland, and James Stevens at trial. In support of this motion, the people further state as follows, and then they go into the background. So the background, we've already heard this stuff, you guys. So what I'm going to do is I'm going to just scroll through this. And if you want to read it word for word, you can go back and watch the replay of this and just pause it. Like I said, this here is just reiterating again what we've already read. But like I said, if you want to read it in full, you can. Okay, so right here, while they're fighting to try and get this back in, that's the text, the 381 text messages, 25 calls, 58 saved locations. Some messages were recovered, however, to include a May 6, 2020 text sent from Suzanne Morphew to the defendant that says, "I'm done. I could care less what you've been up to or have been for years. We just need to figure this out civilly." This text goes directly to motive in this case and rebuts the defendant's continuous claims after his wife went missing that the relationship was without problems. So I wanted to highlight that. Okay, and then it goes on for Kevin Hoyland. The report uses the previously extracted phone data from the defendant's phone to show a pattern of airplane mode. Megan Dude, the expert in CODIS DNA. Megan Dude provided information related to a potential CODIS matches discovered in DNA mixture developed from the glove box area inside the victim's Range Rover. Her testimony rebutes a likely defense theory that the DNA from the glove box relates to some unknown violent sex offender from out of state. Although brief, Mrs. Duke's testimony will explain that these comparisons are based on a limited generic information. Okay, so the defendant has been in receipt of the expert's opinion reports associated with Ken Hicks, Stevens, Hoyen for many months in advance of the original disclosure deadline. The following chart summarizes the timeline for which these reports were turned over to the defense. Also attached are receipts of discovery downloads corresponding to the dates these reports were received by the defense. So Ken Hicks, the expert in the telematics, this is when they sent it. The reports were disclosed on 7/23/2021, and then the CV disclosed on the January 3rd. Or March 1st. I don't know. I think in the States, it's the month, the day, and then the year. So this would be July 23rd, 2021 that they first got the disclosed report. James Stevens from the forensic computer data analyst expert. They got that on July, I think it's July 23rd, 2021. Either way, it's still in 2021. Yeah, that's the day. So they go the month, the day. Okay. They got it again when they were asked for the CV report. They got it again on March 1st, well before the deadline. Kevin Hoyland, the phone tracking and historical data, call data analysts, they got that on January 3rd, 2022, and then again on March 1st, 2022. So the prosecution here is showing, like, look at, they're lying. Yes, they did get it again in March, but they'd already had it from the July 2021. Ken Hicks is the only witness in this case who prepared a telematics report from data extracted from the defendant's truck. The report is 10 pages long and not at all complicated as far as expert reports go. The defense specifically claims that this is a law enforcement report, which suggests this is a lay witness, but there are no expert opinion reports. And they're saying, yes, we did turn that over. And they gave the date as to when and what they turned over. Okay, so thus, with the exception of the CVs for Mr. Hicks, Mr. Hoyland, and Mr. Stevens, although the disclosure was turned over, the CV wasn't until March, but they still had the information. All materials associated with these experts were disclosed well ahead of the court's February 14th and 28th, 2022 deadline. In this motion, the D, here we go. This is the one that I said he hasn't ruled on yet. Whoops. The D26, the D62B. The defendant acknowledges having the reports from James Stevens, Ken Hicks, but claims that these reports are not reports that express expert opinion. And they're saying, yes, they did. So they had them, they just didn't have the CV yet of them, although they did still have the disclosure of it. Next, the defense claims that they have no evidence of Mr. Hicks' opinions, and the people have not produced any analyst summary or investigation related to the extraction. Simply, the data was exported. This claim went even further at the March 10th, 2020 hearing, when Ms. Eaton claimed, we don't have any expert opinion about what his extractions show. We don't know what his opinions are going to be regarding the extractions. We don't have any analyst summary. So they said they didn't have anything. They just said, hey, go find. They said, we don't have any, okay, that the data was exported. They did not produce whatever it is that they want Ken Hicks to rely upon in terms of their expert disclosure. They did say, hey, go find it yourself. Well, it is up to you to go find it. If you want that information and we send it to you, along with all the other information you wanted, that's up to you to find it now and there. So they said, go find it yourself. Go figure out what you think Ken Hicks is going to testify to. But they're saying that they did give the transcripts of what he was going to testify to. So like I said, if you want to read through this, you can pause it in the replay and read through it all, because we've gone through this all already. Okay, so not only did the defense reference telematics on dozens of occasions and clearly show an understanding of the expertise, they introduced several exhibits at the preliminary hearing showing that they were in receipt of the underlying data that the telematic report was based on. And they did. They used that at the preliminary proof evident presumption grade hearing. Okay? So they had it, but now they're saying that they didn't have it. Exhibit DD was introduced in cross-examination of Commander Alex Walker on August 9, 2022. This exhibit is the first 24 pages of 624 total of the raw data from the Burla that was the basis of the telematics report authored by Mr. Hicks. So they have all this. Everything that they're going to be testifying to, they have. But they're saying that they don't have it. We don't know what Mr. Hicks is going to say. Well, you have 624 pages of what they're going to be basing their opinions on, which is their expert testimony. Yet months after the defense repeatedly told this court that they had no idea what Mr. Hicks would testify to or what information he relied on. Well, they do have it. They have the whole 624 pages to what he's going to testify about. So the defense is lying here when they say, we don't have anything about what he's going to base his expert opinion on. You do. You have the full 624 pages. So I don't know how the judge is making a decision just because the CV wasn't there as to what exactly they're going to ask him. They know that anything they ask him is going to be based on this 624 pages of his report. So like, I do feel that they are just trying to bury the prosecution. And normally unless they feel they have a good chance at winning, they're not going to attack it the way they are. And I do feel that the defense is saying, okay, yes, we do have his full report, and we do have the full 624 pages. And we do know the prosecution is going to be asking this expert witness questions based on this 624 page report. But we don't know what in this 624 page report is going to be questioned or is going to be used. It doesn't really matter. As long as you have the full report, you've got everything that we could possibly ask him questions about. And that goes on to explain the same here with each of these people. They did have the reports. But they wanted it with a pretty little bow on it. This is the question we're going to ask, and this is what we think he's going to answer. No, you have the report. So the CV, regardless whether you got the CV late or not, you still have had that 624 page report since last year. So you know whatever's in that report is the only thing that we can question the witness on. You know, it's splitting hairs because the CV report was a little late. So like I said, you can read through this if you want to rewatch the replay of this. And don't forget, when the replay starts, you guys, it goes, once this live is done, it's not going to be available for about 20 minutes. And then it will be available again for you to rewatch. So if you do want to rewatch this and go through this word by word, you're more than welcome. It's just with my eyes, I can't do this. The defense inaccurately categorized Mr. Hoyland as a witness that they received no report or no expert report at all. Instead, a footnote is included suggesting that they in fact do have a report because his report is labeled a draft, that it cannot actually be considered a report. So they had that and they produced that. So don't tell us you don't have it when you just produced it. At the preliminary hearing, the defense repetitively asked witnesses about the cast report authored by Kevin Hoyland. Mr. Hoyland is referenced 16 times at the hearing, and the cast report is mentioned 46 times. In her questioning of Commander Alex Walker, defense attorney Drew Nielsen asked the following. In the course of your investigation, you also work closely with an FBI agent specialized unit called the Cellular and Analyst Survey Team, CAS. Yes. And CAS provides analysts of cell phone records and present information to law enforcement, correct? Yes. And you worked in conjunction with CAS since early on in the investigation? Yes. You spoke with Special Agent Kevin Hoyland with the FBI CAS 2 days after Suzanne went missing, correct? On May 12th in your affidavit page. Okay, and they displayed the results, and she was reading from the information that the prosecution had sent over to her. So how can you say you don't have it? How can you question a witness about it, about something you don't have? You have the report. So she just outed herself there. Don't say you don't have the report when you do, because you wouldn't be able to question this witness about it if you didn't know it existed and didn't have it. Okay, and you consulted with Special Agent Hoyland of the CAS while drafting search warrants to cell phone records. That's correct. Okay, so the above exchange was one of many by the defense lawyers asking about the findings of Kevin Hoyland and the data he collected. And yet Ms. Eaton repeatedly asserted at the March 10th, 2022 hearing, we don't know what Mr. Hoyland's going to testify to because the only report he drafted was in from June, which we have. And it's termed a draft CAS report. See the transcript. This sort of blatant contradiction has been continually tactic to mislead the court into believing discovery violations are rampant when, if anything, they're technical in nature. So they got that back in July of 2021. This is one of the ones they said that they have no idea what he's going to say. They've had nothing from him. Well, they do. Because it was marked draft, it doesn't mean that you didn't get the report because it was marked draft. That's what they're using. So you do know exactly what he is going to testify about. The defendant has been in possession of all materials related to Megan Duguay for many months, and her CV was discovered well before the original disclosure deadline. Whoops. Duke from CBI will testify to the CODIS hits discovered in the victim's Range Rover and the strength of those leads. Okay, and again, they're going through the preliminary hearing where Eaton is questioning her regarding that information. How can you say you don't have the report if you questioned them about it, what's in that report, back in August 2021? How can you say you don't have the report? You used that report back in 2021 to question this person on the stand. But now you're saying you don't have that report. So I get where the prosecution is coming from. Just because you don't have the CV doesn't mean you don't have the report. And they're saying that they've got no information. They're going to be blindsided. They don't have any knowledge of what these expert witnesses are even going to testify to, when she's lying straight out. Because they had that back in 2021 because she used it at the proof evident presumption great hearing to try and get her client out on bail and the charges lessened and all that crap. How can you say you don't have that report when you used that report back in 2021? So she's really exaggerating this to try and get exactly what they got. Rule 16 requires the prosecution to provide, upon court order as ordered here, the underlying facts or data supporting the opinion in that particular case of an expert endorsed as a witness, the expert's report, and if no report exists, a written summary of the testimony describing all discovery violation related to the materials associated with Mr. Hicks and Mr. Hoyland and Mr. Stephen. First and most important, where do I want to get to? Okay, here. First and most importantly, all material related to the substance of what Mr. Hicks, Mr. Hoyland, and Mr. Stevens will testify to was provided to the defendant well ahead of the February 14th and 28th, 2022 expert discovery deadline. The only material provided 1 day late was each witness's CV. Okay? As noted by the people at the March 10th, 2022 hearing, the failure to provide the CVs of Mr. Hicks, Mr. Hoyland, and Mr. Stephen was inadvertent. The people fully believe the defendant received the CVs on February 28, 2022. The failure to provide these documents to the defendant until March 1st was merely an oversight. The people cured this issue by providing the CVs as a mere no discovery violation related to materials associated with Mr. and Mrs. Duge. With regard to the 1 day delay in the discovery of the CVs for Mr. Hicks, Hoyland, Stevens, blah, 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 the people implore the court to reconsider its severe sanction of excluding these witnesses. As the court is aware, in the criminal justice context, the need to find the truth is paramount interest at stake when considering discovery violations. So the ultimate purpose of discovery sanctions, like the discovery process itself, is to advance the search for the truth. Therefore, any prejudice resulting from a violation should be cured by the least severe sanction, such as a continuance wherever possible. Generally, sanctions as severe as dismissing a case or excluding witnesses only occur when discovery violations are at issue during trial, not almost 2 months before the trial, as is the case here. Okay, and then they're citing cases here. Several examples of appellate review provided further guidance where the court found that the discovery violations were inadvertent rather than willful. The trial court had abused its discretion in granting a dismissal. Where the prosecution had not disclosed a videotaped interview with the juvenile, blah, blah, blah. Okay, they're citing other cases. So they're saying that the people cited to Rule 16 in our argument on March 10th was as a way of disrespecting or ignoring the court's authority to issue discovery orders, but to explain the lack of prejudice to the defendant. In criminal cases where case management orders are not in place, Colorado statutes and case law have made it clear that receiving expert endorsements 35 days prior to trial does not create prejudice. The only reason I'm going through every one of these, you guys, is so for the people who do want to go back and read this word for word. The Honorable Patrick Murphy found a discovery violation on July 22nd, 2021, but did not find any willful misconduct on the part of the district attorney's office, and ultimately found that the issues were remedied even before the preliminary hearing date. In this court's ruling from March 10th, there was again a finding that the brief delay in CVs was not willful, but that there was a pattern of neglect from this case. This pattern was based on Judge Murphy's initial finding of a discovery violation combined with this court's second finding for late CVs, which was only 1 day late, for some experts at the February 28th deadline. And rather ordering a 1 day recess to allow the... okay, this is going back to where they were citing another case here. Okay, so the exclusion of these witnesses damages people's case in a profound way. In a no-body homicide case such as this, the timing surrounding the victim's disappearance is everything. The defendant admits he is the last person to see Suzanne Morphew alive, and thus his credibility is the certain question the jury must resolve. By excluding the most damaging impeachment information against this defendant, the cell phone data, the truck, telematics, and the GPS locations, the court has imposed sanctions tantamount to a dismissal, with the defendant suffering a complete windfall. The court's basis for the sanction was derived from a perceived prejudice the defense suffered in not knowing what the people's experts would testify to. This motion for reconsideration aims to clear up the factual record and in turn shows the defense's assertions that the court relied on to be false, completely exaggerated. As a subsequent issue, this court also found an additional Rule 16 violation at the hearing on March 30th, 2021, but again found the violation was not willful and striking the individual witness was sufficient as a sanction. That's where they got rid of the dog handler. The people have heard the court's concerns regarding compliance with the CMO, understand the court's and defendant's frustrations. In total, the court has stricken 12 out of 14 of the people's proposed expert witnesses, and yet the people are not asking the court to reconsider the order from March 10th in its entirety. Instead, the people request that the court reconsider its order in regard to Ms. Duge, Mr. Hicks, Mr. Hoyland, and Mr. Stevens. Wherefore, the people request that the court reconsider the finding of a discovery violation related to the disclosure of materials related to Ms. Duge and allow her expert testimony at trial. And further, the people request the court reconsider a sanction for the discovery violation related to Mr. Hicks, Mr. Hoyland, Mr. Stevens, and allow Mr. Hicks and Mr. Hoyland and Mr. Stevens to testify as experts at the trial. And this is by Linda Stanley. So, like I said, you guys, these, those there were what they filed on the 1st. So here is other ones that they then filed on April 7th. Let me just share my screen. So a week later, they filed this. Okay, so I had to take a sip of my coffee there, you guys. Okay, so Linda Stanley then filed this on April 7th. Soon after receiving the March 10th, 2022 hearing transcripts on March 28th, the people submitted the title Motion to Reconsider Discovery Violation Sanctions. On April 1st, in his response, the defendant, through counsel, repeats several inaccuracies as it relates to the state of the discovery and other issues. Simply, they are shifting their arguments away from the issues at hand in this motion. For each witness discussed in the motion to reconsider and the response, the people offer the following reply. Discovery admission by the defense. The defense finally admits that they had Mr. Hicks' telematics report, but complained that it was difficult to find amongst the other disclosures from that date. Well, that's not the prosecution's fault. They had it. In Mr. Morphew's renewed motion for discovery, sanctions D-17 filed on August 2nd, Mr. Morphew provided photographs of the voluminous, disorganized, and chaotic nature of what had been disclosed. See Exhibit 1, D-17. So while it is true that now directed to Hicks' report, Exhibit 1 in their chart was produced to the defense on July 23rd, 2021. It was produced amongst 1,771 other pages of discovery on that date and contained within the approximately 4,000 gigabytes of data that has been produced so far. Okay, so the judge excluded this witness because they believed Eaton saying that she didn't have the report when in fact she did. Notably, this report was disclosed the same day as Mr. Stevens' report, along with all the other data from the Rocky Mountain Regional Forensics Crime Lab. This information was batched together intentionally for ease of access, since it covers the vast majority of material produced by this crime lab. The 10-page report is included as Exhibit 1A of the motion. The report was produced along with the underlying data notes that the expert used to formulate his opinion, information the defense has consistently complained that they do not have. And yet the defense argues that since his notes were so voluminous, it was difficult for them to ascertain what his opinions were. Neither the CMO nor Rule 16 require that the people to spoon feed the defense the location of certain reports. Nonetheless, the defense does not dispute that they have had this information since last summer and even used the findings of this report in cross-examination during the preliminary hearing. Given the discovery was labeled differently in June and July of 2021, the people necessarily relied on the old bait stamp numbers. Apparently, this is a point of contention for the defense, but it does not take away from the fact that these reports were disclosed long ago. And despite claiming otherwise at the March 10th, 2022 hearing, the defense now admits that they were in receipt of these opinions. So what I'm saying here is what I said now that I have this report, what I said when we were going through the defense's motion. Wait a minute, you guys had all this. I know they had all this. I know they had it all because I remember it being brought up at the preliminary. Okay? So just because you guys had a hard time finding it, you shouldn't have asked for all this information all at once, and you wouldn't have 4,000 gigabytes to have to go through to find it. So by what I'm seeing here, being that they did have it, those expert witnesses should be allowed back in. And that's why I'm saying I think the best case scenario for the prosecution is to go to the Supreme Court with this, because it does not look like Judge Lama is going to allow these people in, and to wait until the 19th to try and get him to overturn this. And judges very rarely overturn their orders. But this proves that they lied. They lied, and the judge believed them. Okay, so here's the next page. I'm going to scroll through this slowly, so if you guys want to go back and, like I said, in the replay and watch it, you can. Okay, the defendant is the one that gives context to this expert's findings. Who are they speaking about? Okay, the same one. When confronted with this information, the defendant confesses to making these various trash runs, which makes the defense's argument that law enforcement cannot say they know who was driving the car rather unbelievable, right? He admits to it. Finally, the defense doubles down on their claim that they do not have the underlying facts or data supporting the telematics information, despite claiming they lost this witness report because it was discovered along with too many other documents. It was sent over to them with the other notes and findings of the same witness. And despite literally admitting the underlying Burla data used to create the telematics report at the preliminary hearing. Okay? So they've lied again, saying they didn't have it. And they used it at the preliminary hearing. I think they should go directly to the Supreme Court with this right now. Stop waiting. One more. The defense admits to having this report. Okay? This is James Stevens, where he's been denied being able to testify as an expert witness because they said that they didn't have any information from him. Once more, the defense admits to having this report. This is a welcome change from their position at the March 10th hearing that suggested there was no written account of his analysis. Okay, so here's another one. They had all these reports back in June and July of last year. Just because they're having a hard time finding it within all the voluminous information that they received, they shouldn't have asked for all that voluminous information by select dates. And it could have been maybe organized a little better for them, but it's not up to the prosecution, like they said, to spoon feed them and say, okay, look, go to page 4 now. Okay, wait, go here now. That's up for them to do. They asked for the information. The information was all sent. If you would have asked and given us a longer deadline, we could have broke it down to, okay, what we're sending you today is all the telematics. What we're sending you today, the next day, is all the cell phone data. What we're sending you the next day is going to be all this. They didn't. They wanted it all at once. You got it all at once. And now they're complaining about not being able to find things. Just because they can't find it doesn't mean that it wasn't sent. And that's how they got all these experts taken off as expert witnesses, saying that they didn't have their reports. They did. Okay? The defense even accurately relays that they have 2 reports from this expert, which is consistent with his analysis of multiple devices in this case. The 13-page report attached to the motion as Exhibit 2A, however, shows his analysis as to the defendant's phone download. Mr. Stevens notes and summarizes of the steps he took to analyze this device were also included and attached as Exhibit 2. Despite this filing, the defense still claims they do not have the underlying facts and data, and therefore this endorsement does not satisfy the disclosure obligations outlined in the CMO. This statement is factually dishonest and full of contradiction. So here, the prosecution is coming back saying, because if you remember me commenting, going, come on, you guys, this is the smoking gun. Why wouldn't you have given them this information? You've just blown the case, or could have just blown the case by not disclosing this. They did disclose it. They did, and they're proving it. Okay, so substance of the expert reports. The defense is well aware that the experts who perform extractions do not provide an opinion or analysis on the contents of the discovery, as they are not investigators. Mr. Stephen does not know which text message is valuable to an investigation, or that a recovered text from the defendant's phone on May 6th threatening divorce is highly probative of a motive in intimate partner murder. And so, of course, this information would not be highlighted in his report because he's not an expert on that. He's just the expert that's extracting everything. Look, this was deleted. I've been able to extract it. Here it is. He doesn't know if that text is actually going to be able to be used. That's up to somebody else, a different expert, to decide whether that is going to be able to be used and what information is going to bear on that and what evidentiary value does that text have. That's not up for this guy to decide. He's just there to extract deleted items or any other information that is on that phone. He's not the expert in determining what is evident and what is not. Okay? And yet the defense wishes this court to strike this witness while allowing the defense to play by different rules. The defense endorsed Matthew. So the defense endorsed already, so agreed, Matthew Eckerson as a defense witness to testify about his extractions from an HP laptop found in the Morphew home. In comparing this defense expert witness report and disclosures with Mr. Stevens' disclosures, this court can clearly see that the people more than complied with the requirements of Rule 16 and the CMO. The defense disclosure for Mr. Eckerson is as follows. Okay, so this is what the defense said. Matthew Eckerson is a lead computer information technology and mobile forensics expert for U.S. forensics, blah, 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 blah. He regularly uses forensic tools such as NCASE, Celebrate, Oxygen, Secure View, Autopsy, FTK, DME, DART. These are all programs I use to extract information, okay? And X-Ways to perform and analyze data extractions, and is adept with Windows Server, Windows Mac, so it covers all forms of operating systems. Mr. Eckerson has also established and documented methods and best practices for evidence handling in the scientific and forensic communities. Mr. Eckerson's expert findings and opinions are based on his education, training, and expertise in the field of digital forensics. Mr. Eckerson will testify that the prosecutor's expert sent him the image of Suzanne Morphew's HP laptop in December 2021. There you go. Mr. Eckerson will testify about the data obtained through his extraction and or analysis of the image laptop. So there they go. This endorsement does not disclose the underlying facts and data that this witness used to extract the laptop. Does not even list the data obtained, does not include any single mention of his analyst, and leaves the people to guess what he may actually testify to. So they're doing, this is what they said about their expert. They didn't disclose anything. They didn't say what he found, how he found it, anything. And what the people leaves the people to guess what he may actually testify to. At least the defense, the prosecution said to them, this is the report, this is what he's found, and this is what he's going to be testifying on. They said none of that. They just said, we got an expert and he's going to testify to what he found. They don't say what he found, how he found it, anything. So they leave the people to guess what he might add. Okay, so this is a violation. The defense cannot simultaneously argue that this endorsement is sufficient for a defense expert witness that did extractions and also continue to claim that Mr. Stevens' multi-page report is inadequate or that they lack sufficient notice of the expert's testimony. Unfounded and contradictory claims by the defense should not be basis for the exclusion of key evidence by this court. Okay, so that's with Kevin Hoyland, expert cell phone tracking and historical cell data analyst, discovery admissions by the defense. Again, the defense said that they didn't get Kevin Hoyland's reports and all this. This goes to prove that In fact, they did. Okay. Okay, after the hearing on March 10th, Mr. Hoyland submitted a more finalized report using the same information that he had previously relied on for his original report. So they again gave them another report, okay, because they either couldn't understand the last one or said they didn't get it, whatever, but they did. Oh, well, these reports are essentially the same. The people are only asking the court to allow Mr. Hoyland to testify to the contents of his original report, recognizing that the finalized report came in sometime after the disclosure deadlines. The defense still does not present any argument as to why the original report that they had back in 2021 should be disallowed simply because it is labeled a draft. Nor does Rule 16 or CRE 702 prohibit such a practice. Mr. Hoyland's report was based on his use of the telematics discussed under Mr. Hicks' disclosures, a call detail record or CDR, data from Suzanne and Barry Morphew's phones. The defense continues to suggest that they do not have the underlying CDR data Mr. Hoyland is going to rely on for his testimony, right? Despite admitting it in their own filing to the contrary. See Exhibit B. And that's what we just talked about beforehand when they filed reports saying that they got the report and it's only a draft, and they had that back in 2021. Okay, when it was originally filed back in July of 2021. So what they did is they gave a final report as to what he's going to testify to, but it's nothing that isn't in that draft report. It's just in clearer form. So there's nothing new that isn't in that CDR draft report. There's nothing new. He is going to be giving testimony on what is in that draft report, nothing more. So, and because that report was filed back in 2021 on time, they should be able to use it, and he should still be able to be called as an expert witness on that draft report for information contained in it, which is the same as the report he drafted now. Okay, so again, they're going over the vast majority of the defense's objections to these experts through the responses have no bearing on this motion to reconsider. The defense clearly knowledgeable of this expert's reports and have even prepared inquiries as to the strength of his ability to tell if the phone actually enters airplane mode. So they've even questioned him on that report. Okay? So they can't say they don't have it, but they lied to the judge and said they didn't have it. So the judge excluded him as a witness. Megan Dooch, the CODIS. The defense spends 2 paragraphs in the response listing out the emails and reports contained that contain Mrs. Dooch's opinion, only to say they cannot identify her opinions or find her reports or emails. They do not dispute that they were in possession of these items as well as Mrs. Dooch's CD well before the disclosure deadline. Although brief, Mrs. Dooch's testimony will explain the CODIS hits. So she's being excluded, but they had her disclosure long before the deadline. But the judge excluded her. And this is why I think, you guys, that they should be going to the Supreme Court. So all this information can be in. Okay. So for 7 witnesses, okay. They implied these witnesses wrote a law enforcement report, but they do not have expert opinions. The only logical inference from this categorization is that they believe these witnesses' testimonies do not require an expert endorsement. For Mr. Stevens, the defense informed the court of the following. James Stevens. Mr. Stevens appears to have extracted data from Mr. Morphew's phone. The defense has no expert opinion reports. Yes, they do. Paragraph identifies what Mr. Stevens will testify to, and yet says it has no expert report, right? So they're saying they know what he's going to testify to, so they're contradicting themselves. Okay? So the paragraph identifies what Mr. Stevens is going to testify to, and yet says it has no expert report. How can you know what he's going to testify to if you don't have the report? Right? They've lied. So how the judge is excluding them, I don't know. The defense makes their position even more apparent for Mr. Hicks when they write, the defense has an extraction report about the examination of data from Mr. Morphew's Ford F-350. An expert opinion report would be expected to contain expert opinions, yet there are none for this witness. In that report would be his opinion. Oh, hello, my brother from a different mother. Nice to see you pop in. Been worried about you. I hope everything is okay and going according to whatever plan you have. Nice to see you. Okay, so the next one. Okay, the next one is this one here. The defense literally identifies the telematics extraction report and could not be any clearer that they do not believe the contents of this report contain any expert opinions. In line with the argument, the defense requested the court to do the following. 1, bar the proposed experts. 2, lay witness law enforcement reports, only few CVs, permit the witness to give lay opinions but not testify as experts. 3, limited subject expert report, restrict the witnesses to the 4 corners of the reports. Or category 4, the medical witness, permit expert testimony subject to a separate Shrek motion or challenge. Only after the court granted their specific relief as a sanction for the late disclosure of the CVs, which were only a day late, does the defense now ask for even more by striking the witnesses entirely. As the people understand the court's order, information in Mr. Hicks and Mr. Stevens' reports may be testified to in lay capacity. The defense's subsequent motions has the court to resanction the people for conduct, and the court has already decided on. With all the back and forth in these motions, the court should not lose track of what ultimately constituted a violation of the CMO and the potential of prejudice that justified the severe sanction imposed by the court on March 10th in striking 10 out of 14 of the people's expert witnesses. Don't forget, he also strike 2 more. While the defense's arguments to the court on March 10th went as far as to say they had no knowledge of the expert reports, the response brief only articulated that they believed the reports were insufficient under the CMO. The court has the reports and can make a determination as to sufficiency of the information, but it is clear that people have shown and the defense has ultimately conceded that they had these expert reports in their possession well before the disclosure deadline. Neither this court nor any previous found willful conduct associated with any discovery violation. The court found a pattern of discovery violations based on Judge Murphy's previous finding in combination with the late disclosures of the expert CV hours after the February 28, 2022 deadline. So don't forget, February only had 28 days. So the very next day, the deadline was the 28th. They got the reports the very next day, 1 day late. So you're going to take away all our expert witnesses for being 1 day late for a CV notice document? No. The latter finding, combined with the court's findings on prejudice, form the basis for the sanctions at issue. For clarity, the people do not believe the court should ever consider the financial costs of paying lawyers to respond to motions as evidence of prejudice in a criminal case. Otherwise, indigent defendants would never be able to claim the same level of harm. Ultimately, the sanctions imposed greatly damaged the people's case, tantamount to dismissal. for late disclosures that were not greatly prejudicial, but rather technical in nature. As a comparison, the defense is now responsible for 2 timely technical Rule 16 CMO violations. Okay? So the defense is in violation of Rule 16 also. As the people point out in our response to D66, the defense disclosed the existence of an alibi a day after Rule 16 requires. See motion to strike untimely and vague notice of alibi. While no doubt a violation, the people have not suffered extreme prejudice due to this day late filing, even though it happened much closer to trial. Similarly, the court issued a CMO, required parties to submit a motion in line by April 5th, and yet several of the defense filings were not submitted until April 6th. These late filings are technical violations of the CMO, but again, the people cannot, in good faith, argue that these disclosures submitted only a few hours late greatly prejudice the people. As such, the people would not expect this court to strike crucial elements of the defense's case based simply upon these technical violations. This comparison belays the position of the people are placed in by the court's order. The people turned over to the defense the reports before the deadline, and the experts see these on March 1st, still many months before trial. An unintended single day delay in turning over CDs to the defense does not rise to the level of extreme prejudice, despite the defense's continuous recitations to the contrary. The people ask this court to reconsider the severe action imposed only as it relates to the most crucial of expert witnesses, Ken Hicks, James Stevens, Kevin Hoyland, and Megan Duguay. So, there you've got it, you guys. That's what they have requested. We don't know how the court's going to rule. Okay? We don't know. Let me just see this here for a minute. We don't know. Oh, let me just put this over here so I can see if any super chats come in. Hang on. Okay, so we don't know. The court, I don't think, has made a ruling on that yet. There's me, Kay. You're very welcome. It was very hard to find these filings. I don't know why these are not in the record yet. The only one that I have been able to find is the one response by the defense. When the prosecution filed a motion regarding the March 10th order, the prosecution filed paperwork April 1st and April 7th, and we never could find that. It's still not on the record. But the defense's response is, we don't even know. It's hard to make hide no tail of that. That's what I showed you a couple days ago, because we didn't have and still do not have on the court site the filings I just showed you. We still don't have them. They're still not on the court site. One, I know, I don't think they are. So what I said right at the beginning, that right now the prosecution is in a very sticky situation. As far as I'm concerned, they should be going right straight to the Supreme Court, because I feel like the striking that Judge Lama did, 12 out of 14 witnesses, is extreme, should never have happened, and I think they should go above his head. Yes. AK, are you in a position where you can check the record right now? Or do you want me to just... Is there any way that you can do that? Are you at your computer or are you on your phone? to see if the filings from the prosecution on April 1st or 7th, if they're on the record yet. They haven't even been putting the minutes in. If AK can't look for that, I will do it for you. I don't think so. Okay, thanks, AK. Okay, so the Supreme Court is involved now. We won't get that publicly, no. We won't get that publicly. So I do believe that what's happened is the prosecution has said, screw this. We're being sanctioned. That goes above and beyond what Lama should have done. He's basically given them a dismissal by doing what he just did. Now, they haven't, I don't think the judge has responded to their request because they had the testimony and they can prove they gave that testimony to them back in 2021. So they're saying, look, we want these. We can prove that they got the disclosure. They lied about not having it. They also used that disclosure in the preliminary proof evident presumption grade hearing. They're lying to you, Judge. Unless they can get that back, maybe they've tried and the judge has said no and still just excluded them all, then yes, I do hope that they are. AK's got better ways of finding things out than me, you guys. He's checking right now to see if what I just showed you is in that record yet, because it should be. Oh, yeah, he's handed it to the defense on a silver platter. Absolutely. Thank you again, Maui Swift, for your super sticker, and Elizabeth Gregory. Thank you, thank you. And with that, Elizabeth Gregory, sorry about that. I finally see prosecution is responding, a little snarky too, which finally, but why did they wait till now? Also, thank you for everything you did. She did that with a super sticker, so thank you. Oh, unfortunately, that won't come up on, I can't put that on screen. AK, been a member for 6 months. You're saying 3 months. What's 3 months? 3 months what? I just seen that pop up. And that's what I mean, you guys. If you guys have a specific question you want me to answer, throw it in a super chat or super sticker. It pops up on my screen. But unfortunately, the free ones I cannot put up. I don't have it today. It must be picked up in person. Yes, but it still should be the daily register of actions. Yeah, have to be picked up in person. But the stuff that I seen, the prosecution's motions that they have used and filed should be in the continuing record, but they're not. Yeah, the register of actions. There's a person who picks up the register of actions daily. She was going to start sending them to someone else on Twitter. I'll get them latest by 4 p.m. Cool. So that's how we know, because the daily register of actions show what's going on in the case. It's sometimes in a form of only partial words and stuff like that. But anybody that has expertise or knows how to read court records can read what that actually means, that, without it being said in full. But what I was looking for, Kurt, was court can make them available. So he's saying the motions are being requested and are being released as the clerk can make them available. Yeah. So, but they should already be, these are from the beginning of April. They should already be in the court record online. Like we can see in the Lori Daybell, Chad Daybell, Letitia Stout. Each time something is filed, it's automatically in the court record. We're not getting that with this case at all. At all. Like, they don't want the people to know. Like, look at the defense is blatantly lying to this judge, and the judge is accepting it. If the judge doesn't overturn his order, I think there should be something done about him, because he's been shown proof that this stuff was handed over. Alma, I don't believe that for a minute. Like, I know, and I'm not squashing your opinion. You're entitled to that, and I appreciate it. There's tons of evidence against him, and that's why they're trying to get all these witnesses out. And I feel that the judge is taking the defense's side, and the defense has out and out lied, exaggerated everything to get the judge to throw these expert witnesses. And it is now proven that, and they have even admitted to it, that they've had testimony that they said that they didn't have. Yeah, they don't want the case thrown out. Comp Toot, I don't see your super chat. Yeah, the judge is going to have some issues himself, because he has gone to the extreme. He's basically given a dismissal and handed it to the defense by excluding all these expert witnesses that prove this is a circumstantial case because they don't have a body. So by the judge doing what he did, he's handing it to the defense. He might as well have just said, I'm dismissing it. But he can't do that either. So he's done backdoor dismissal. That's my opinion. He's done a backdoor dismissal. Maybe my sister can help you out there, Comp Toot. Sister, if you are available, or one of the other mods that can help out Comp Toot. You do have to scroll down to the bottom. Once you fill everything out in the super chat, you got to scroll right down to the bottom and click purchase. There's a new button that's on there that you got to click purchase on. So make sure you scroll down when you do each of your super chats. Make sure you continue scrolling down even once you can't just hit enter or whatever. Okay. Where's AK there? The only documents released, he said, are the defenses. Rarely do we see the prosecutions, but in the other case, we see both. We see the prosecution and the defenses, especially that when the defense files a motion and the prosecution responds, we see that in the record too with the other cases, even with Letitia Stouts. Shivani says, in my opinion, the presiding Judge Lamas is someone who's prejudicial in favor of the defense. Yes, I'm getting that same thing. And Shivani, I seen in the comments you had said that somebody had removed a comment. No, some of them go directly, and I don't know why. But they're sometimes when you put a comment on the videos, they go into another folder. They don't go up in the comment section until they're okayed. And that's out of my control. So no, I always okay your comments. I love your commentary, and I love your in-depth comments that you make. Oh, thank you, Alma. Yeah, right now, I'm going to say that the defense, it's their case. They're going to win if this stays the way it is. So I agree with you there, Alma, but there is so much evidence that they have to prove. Number one, he's the last one to see her live. We were in the middle of COVID. You weren't allowed to leave your house, go out shopping and all that crap. So Suzanne would have gone nowhere. Her passport wasn't used, so she's not out of the country. None of her money or banking or anything's been used. Her cell phone is gone. Her all her ID and everything was left behind. You know, on top of that, who is the only one that has something to gain by Suzanne, as Dawn Wells would say, got gone? Who? She wanted a divorce and she wanted out. Barry was going to lose half of everything. It's a $2 million $2 million reason why he wanted her gone. Oh, is Ashley gone? Is Ashley gone, Kurt? Oh, super chats are frozen. That's weird. There we go. Thank you, AK. There we go. I guess they're back up and running. Barry did kill Suzanne. 100 million%. 100 million%. She's a firefighter now. Yeah. Ashley was a news reporter that was pro Barry. She also got a lot of documents before they were even filed. How did she get them before they were even filed with the court? Even though they may not be up on the site, you can go into the court and request the documents. But how can you do that if they're not filed yet? The documents that she shows don't have the filed stamp on them yet. So they're not filed. You can't get copies of documents, I don't care who you are, until they're filed with the court. So how did Ashley get documents that the defense was going to file before they were filed? Unless you're working for the defense. Yes, thank you so much for that, Kurt. Oh, Ashley went to work at the fire station? Seriously? Maybe there's something there that she needs to cover up for Barry. Unreal. And Elma says, 200% certain he killed her, no doubt about it. Yeah, but if they do not allow these witnesses in, they don't have a 200% chance anymore. I feel that if they went without being able to have these witnesses, and from what I'm seeing now is the defense doesn't even want them to being able to testify as lay witnesses. If the judge allows that, then they're shot. They're done. Barry wins. Extreme pro Barry, yeah. Spoke our names to the defense. Our names, both me and AK. Our names were spoken to the defense. Kurt does have that when the judge asks about me and everything. And it's like, Kurt, I don't know. It's like, pay for my flight and my accommodation there, and I'll come and answer to you, Judge Lama, because I'd have a few choice words to say to you. We'll catch that last. Compute. Whoops. There we go. Is this the paper that didn't have the court time and date stamped attached to it? Yes. Yes. There is some, AK, from what I understand, there are some that the defense didn't say anything about testifying as lay witnesses, but I believe I'd have to go back through the paperwork, but I believe that there are 2 of those expert witnesses that the defense is saying they don't even want them to testify as lay witnesses. It was just in the paperwork. So thank you for that compute. Linda Stanley did compromise this case. A lot of it was when she went on that podcast that I got shot down because I was totally against it. And I made a comment over there. I'm not going to mention the channel, but I made a comment over there and said, look, she should not be doing this. And the person interviewing her should have known better too. Who is Ashley? The guy from Gone with the Wind? No, Ashley was the reporter. Know anyone else who works at the fire station? Doesn't one of Barry's buddies work at the fire station too? Like, it's just odd. That is odd. Like, I didn't know that, AK. So thank you for letting me know that she's gone to work at the fire station. That's like, whoa. Buried behind the fire station. Maybe. I think that she has been moved several times. I do believe that she was buried in that creek at some point. I really do. Who else works at the fire station? I believe there's others that yeah, that could have been one of the places. I believe she's been moved now a couple times, so that's very possible, Comp Dude. I'm behind a chat, you guys, so okay, you said it, not me. The witness subpoenas have already been sent out, and the jury questionnaires have already been sent out. Okay, Kay says, yes, as there was no opinions, they weren't asked for opinions, i.e. telematics. The person just pulled the telematics for CBI, never asked for an opinion. Compton says, I wonder if it was a trap laid by the court to see who pops up with the papers. Yeah, really, eh? Yep. Yes, and there's more than just Colorado with corruption. Yeah, if those witnesses can all testify, they're done. Barry's gone. No, it was not one of the Morphew girls. It was Barry's sister that confronted Lauren Scharf. Marcy, not Macy, Marcy, which is Barry's sister. Thank you so much, Carolyn Whitfield, for your super sticker. I appreciate it so, so much. Sarah says, and told her something, Barry's sister, thanks for ruining my life. That was said long ago. If I'm remembering correctly, that was way, way back when this first started, that she yelled out, you're ruining our family. You're ripping our family apart. I don't know exactly what was said this time. I haven't been able to find that. So I don't know what exactly she said to Lauren this time. But I know months and months and months ago, last year, she also freaked out on Lauren and said, you're tearing our family apart, you're ruining our lives, blah, blah, blah. At the last court appearance, I know she verbally attacked Lauren Scharf again, and I don't know what was said in that one, so I'm not going to comment on it right now. Yeah, JP was in many things, many, many, many things. His good buddy, the ex-army hunter. Yeah, there was one more recently. She might have said that too. Again, you're ruining our life or whatever. But I know she flipped. I don't know the full extent of what was said at the last court hearing. But I know last summer when she freaked out on Lauren too. So it's like, why isn't she being told she can't come into the courtroom if you're going to pull friggin' stunts like that? I do believe that some are going to be able to testify, but there's two that the defense are saying they don't even want them to testify as lay witnesses. Yeah, ask Lauren if you get a chance. Let me know. Oh, you're not even on Twitter anymore. Send me a message. I sent you a message on the phone. You can send me, I don't even know if it's on right now. Oh, I do. Maybe you did send me a message. I don't know. You didn't. I sent you a message 3 days ago, Kurt, on the phone. Oh, recently, the Morphew girls confronted Lauren too? Wow. I haven't heard about that. You mean George Davis? 4,000 tours in Iraq? Yeah. JP is Jeffrey Puckett. Jeffrey Puckett is the one who went into the motel room after Barry had left and he said it smelled like chlorine. He's the one that Barry is saying that he's a meth head and all this and shouldn't be trusted and shouldn't be believed. That's Jeff Puckett. I think the daughters are standing beside Barry right now because they're after the money. Yeah, I know you're away. Everybody's been asking about you. And the answer I give is just you're taking a break. It's on Lauren Sharf's Twitter page. Okay, let me look that up right now. Let me look it up. She's so pretty. Give me a second, you guys. I can't see chat right now. Just give me a second. I'm looking for it. I see there are multiple fires burning in Colorado. Wow. I hope you're okay over there, AK. Aww. Oh, if you guys, any of you guys that know me, know I think I care more about animals than I do humans. I have more, I don't know. But when I see this, something like this, the El Paso County Sheriff's Office are heartbroken to announce that Canine Jinx was killed in the line of duty last night. That was on April 12th. Oh my God, he's so cute. I hate, hang that guy. Whoever killed him, hang him. I'm trying to search you guys. Like I said, I can't see chat right now. I'm looking and I can't find it. I can't find it. Okay, hang on. I can't find it, you guys. I'll have to look more for it. Sorry, if I could have found it, I would have put it up, but I can't find it. I think the best thing that the prosecution can do is go through the Supreme Court. Yeah. Sad, eh? Seeds of hope. Says beyond all else, Suzanne has lost the only voice she had left, and that is beyond disturbing. It's not a done deal yet. Kat says, I hope you're okay. He's still tired from all those tours, yeah. Yes, Lauren has taken a beating. Did I? Oops. Well, like I said, once the live is done, it takes about 20 minutes for me to get everything in the description and everything. And I will have to, can somebody timestamp it? So I can blurb it out. Yeah, he called Morgan a meth head too. I'm tired from being on break. Yeah, Barry told Jeff he hoped he would catch COVID, and Jeff replied, I hope they find your wife. That was priceless. Priceless. Yeah, that was crazy. Well, if he's found guilty, they get everything, right? If not, they have to stay on his good side, so he'll continue to provide for them. Oh, you're helping with the animals, and get all them animals out for me, okay? It breaks my heart. They don't know what's going on. They don't understand. You can't look at the animal and say, okay, run for your life, pack up your family and run because there's a fire. You know, like they're not like humans where you can tell them you got to get out. I know. So thank you for doing that, AK. Yeah. Seeing an animal hurt or in distress or being beaten on, I'm going to jail because I'm going to beat you. I think there's a lot of money. There's over 2 million between the sale of all the vacant properties, the sale of the Indiana home, the sale, almost 1 million alone just for the Puma Path home. So one residence pays his defense. Yes. I'm so glad he's there helping. Yay. See? AK to the rescue, not just in the criminal aspect. He's there helping innocent animals too. He's got a heart of gold. I've said that right from the beginning, you guys. Yes. Okay. So I'm going to let you guys know also, Barry is back in court on the 19th. It's a pretrial readiness. I don't know if that is going to happen. If this has gone to the Supreme Court, I'm going to rely on AK to let me know what's in the daily updates, which are just the minutes. I can't get them. I'm in Canada, so I can't go there and get them. He can get them. So I will rely on getting information from him for that. But it's supposed to be a pre-readiness conference on the 19th for Barry at 9 a.m. So that'd be 11 a.m. my time. I don't think we can cover it anyway. Also on the 19th, the same day, Chad Daybell is back in court. I want to see what their faces look like. I am allowed to stream that for you guys live. I want to see their faces on John Pryor and Chad Daybell. Lori's been brought back to competency. He goes ahead at 9 a.m. Idaho time. So that's noon my time. I will be covering that. And then Lori is in court at 1 p.m. Idaho time, which is 4 p.m. Eastern. So watch for me to put up those thumbnails for those two hearings. I will be covering both. It's going to be our first look at Lori since she is in over a year. We're going to get to see her on screen, you guys. So make sure you, when I put those up, that you set your reminder for that. You don't want to miss them. Letitia Stout is back in court on the 21st of April. I will be covering that too. And then jury selection starts for Barry Morphew on April 28th. So that's where we are. JP was released from prison super early, made his way into Andy's search, and now is a Chaffee County firefighter living in a house overlooking a super suspect area purchased days after Barry Morphew. I don't know. I haven't heard about that. So you guys, that's not verified. The real girl Angel says, so if Supreme Court, what will happen? Then the Supreme Court will hear the case. Yeah, you got the guardianship just a couple months after Suzanne got gone. Not even. I think it was 6 weeks. He got it in Indiana, and being that he had that in Indiana because the house in Indiana was in the process of being sold, the judge granted him guardianship over her, which he in turn took from Indiana, brought to Colorado, and said, look, I've got guardianship already in Indiana. I need it here too. And they just issued it. It was sick. Yeah, yet. That JP isn't on the witness list yet. They would have to keep it on point because Barry has not waived his right to a speedy trial. So they would have to still go ahead with the trial dates that are already set. Okay, you guys, if you have any specific ones, you're going to have to put them in a super chat because I am so far behind in chat. Yeah, the puppy that passed in the line of duty. Oh, it just broke my heart as soon as I seen that. Oh, this stuff is moving 100%. Good. She was apparently forced to change professions. I don't know why. I doubt that. It's probably an old mugshot. The state's not going to pay for her to get her hair dyed. Something is really strange and deep-rooted in this case. Just what is it that we're not seeing? Oh, I think some of us are seeing it. Okay, so it is verified, not Jeff Puckett. It's another dude, super sketch. CBI overlooked him. Uh-oh. Aww. Kimmy's going to be missing in action. Will you enjoy your trip? Relax and enjoy it. Okay, so I've heard about it, but just not under this name? Really? Because he got guardianship over the house in Indiana because it was in the process of already being sold when she got gone. So the judge in Indiana, not knowing that she's missing, or just knowing, okay, she's missing, maybe she ran. I don't know what he said to get guardianship over all of her financials and everything else. But the judge in Indiana gave it to them because of the sale of the house that was about to go through. And then he took that and brought it to Colorado and said, okay, I need this here too, because we have property here too that I need to take care of. And the judge just issued it. Yeah, the guardianship in Hamilton, Indiana, 50% of his assets are frozen in Suzanne's name. Like right now, the only thing that he can use that money for is for like his expenses, like for rent, heat, hydro, food, gas, stuff like that. Other than that, like he can't go and buy a new house and everything. Like they would have frozen those assets. Yeah, the got gone. Yes, absolutely. Looks like he's lost a lot of weight. A lot of weight. Oh, sorry. Sorry, Marie. Barry looks like he's becoming older by the second. Guilt will eat him alive. Yep. He looks sickly. I got to chuckle at that one. I know, shoes, eyes. Oh, opinionated. Oh, yes. Hello, Seeds of Hope. Oh my gosh, it's been a while since I seen that name. Yes, my dear, I do remember you right from the very beginning of this. Oh yeah, he sold her car, got rid of her clothes, everything. So that's what I got, you guys. I got to write this down so I don't forget. We have the 14th today. Yeah, the status conference that was supposed to happen for for Letitia Stout today has been moved to the 14th of April. And I will be able to stream that live also, so we will get to see her on camera. Let me just get this written down so I don't forget, you guys. Again, I appreciate you all being here and going over this with me. I try to get AK to come up on my lives all the time. Yeah, I'd like to know that too. Just give me a second here, you guys. I'm just writing some stuff down here so I don't forget it. My memory is bad. Okay. Yeah, I'd like to know how he's still working with a proper business license. Okay. Okay, you guys, so we're going to wrap it up. I want to thank you guys all for being here. Thank you to AK for popping in and helping out here. He gets a lot more info straight from the source than I can. He is not far from, well, he's far enough, but he's also in Colorado, so he can get a lot more access to a lot more information. I want to thank all of my mods for being phenomenal as always. Oh, thank you. I want to thank you for being you. I've never met a guy with such a heart that you have. So that's something to be, I'm proud to say you're my brother from a different mother. Your heart is just amazing. And I want to thank you for giving a voice to all the voiceless, especially Suzanne. So thank you for that. Okay, all my mods, love you guys. Thank you for everything that you do here. I haven't seen Miss Missy come in. And thank you to all the people who are members. Subscribers, thank you so very much. Everybody who's sent in a super chat, showing your appreciation. Thank you so much. I appreciate that. Yeah, not all men are jerks. And I'm telling you one thing, AK's got his quirks, but I mean, he's got a heart of gold and he means well, and he puts 100%. If he starts on something, he gives 100%. Awesome husband, awesome father. Although he may tell you different about his little quirks, but he is still compared to none. So yes, he is just awesome and a heart of gold. Miss Missy has been gone. Oh, okay. I didn't get to see her come in. Like I said, I can't see the chat when I'm reading documents and that. So yes, please smash that like button. If you haven't subscribed, please subscribe. I'm going to be doing some updated reads. I'm trying to get caught up, you guys, on the private reads that have been sitting there waiting for a while. I am trying to get caught up. Then I do this to my eye yesterday. So I'm trying to push through the best that I can. So Comptoot, thank you. Thank you. So yes, maybe one day I will get AK up on a live. One day. But I'm going to let you guys get going. I've got a few things that I've got to get going on here myself. So thank you for being here. Thank you for supporting the channel. Stop hacking stuffs. I love you. I love you. I wish I could hack. I wish, because then I'd know exactly what's going on everywhere. Like I said, I have a hard time even hacking. I still haven't got access to my other email. I can't get into it no matter what I've tried. I've tried using my other email that I have for them to send me a code, and it doesn't work. I can't get in. I can't. And yeah, we'll stop hacking stuffs. Or sitting in the Colorado courtroom, right? Live streaming it to myself here in Upper Canada. Yes, see, AK, one of these days we've got to get you up here. Everybody wants to see that. So we will do that one day. Maybe during the trial. Who knows? We'll have to do that because I think AK is going to be there for the trial. So maybe that's going to be our thing. Maybe. I don't know. We'll see. Take it daily. You never know what can happen. Okay, so until the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.